Hi, Commissioner.
Hey, how we doing? Good to see you today.
Nice to see you. I love your mask.
Oh yeah, thank you. Thank you.
Hey, that's a great one.
Yeah, my wife picked it up for me early on and got the whole state of North Carolina there.
How are you doing?
I'm doing wonderful. I'm going to have to leave early. I'm going to cut out early today. I got a county commissioner meeting.
Okay.
So I'll stay on as long as I can, okay?
I sure understand. What time's your commissioner meeting?
My meeting starts at 5.
Okay.
Yeah, but I probably had to cut off just a few minutes before then to get settled.
You bet. Find a parking place, I know. Well, thanks a lot for being here.
Yes, ma'am. Yes, ma'am. I enjoy these sessions.
Well, we got a lot of issues to look at. I think you're on mute.
When you're thinking about things in your own little cocoon and not looking at through the lens of the world, it makes a difference.
It sure does, doesn't it?
Yeah. Yes, it does.
Hello, Ashanta and Natalia.
Hello. How are you all?
Good. How are you all?
Good. Good.
And I think Mr. Woodall will probably have to cut it short at some point. Hello, Karen.
Well, greetings. How are you today?
Good. How are you?
Doing very well. Hello, everybody else.
Hey, how you doing, Karen?
Doing very well. Thank you.
Hey.
Hello, Justice Earls.
Good afternoon.
We're watching you. How are you?
Doing well, thanks.
Good.
Okay.
Commissioner Smith, since you won't be at the end of the meeting, if you have any feedback on any of the recommendations that we've already voted on, just let me know sometime in the next few days.
Yeah, we'll do that. Thank you.
Thank you.
Natalia did a great job formatting them. They look wonderful.
Really. You did a beautiful job. Beautiful job.
Smile, Jesse, you're on camera.
Afternoon.
How are you, Michael?
Doing well. How are you? Hey, everybody.
Tara, you're live and in person.
Only for you, Marcia.
Okay, keep that camera on. We gotta see your smiling face.
I planned ahead just for you. I knew you'd say something.
I guess we scared the Attorney General away. He was there for a second.
I was here, now I'm back in the background.
Oh, no.
Good to see everybody.
Good to see you. Hello, Senator.
Hey, Representative Moore. Just getting my little wonderful camera here together. One moment.
You're combing your hair, I know.
Absolutely not.
And I think we're waiting for Mr. Woodall.
I usually like to use my cell phone for all these Zoom meetings, so I can use my laptop for the notes and other things.
I know.
That doesn't help when somebody texts me.
Yeah. That never happens.
Yeah.
You all may remember if Mr. Woodall was coming in late or early, I'm not sure.
I think he was going to come late.
Right.
So I don't think we should wait on him.
Okay, great. I think otherwise we're all here. It's 4:01. Karen, would you like to, or Michael, do the welcoming or go over anything?
Always. Welcome everyone and to our meeting number 5. And so got a robust agenda as usual. So we're going to begin it shortly with Representative Maury going over the meeting and our goals, but we do have guest speakers, and then of course we'll end our time together with some discussions looking specifically around recommendations for pretrial services and bail reform, and those recommendations already approved. So now I'm going to ask Representative Maury if you would just go ahead and start.
Okay, thanks Karen. Thanks everyone for being here. I know Commissioner Smith has a county commissioner meeting and he will get off a little before 5, so we will move along as best we can. Jim Woodall will join us as soon as he's out of another meeting. So today we're gonna follow up on one more presentation after we talked about bail and pretrial. We heard from 3 excellent pretrial service coordinators last week, Orange, Durham, and Mecklenburg County, and they gave us a lot to think about. And Jesse's here. Jesse, the expert in all things criminal justice, is going to also talk about what happened in Alamance County and the consent order. I think there's a lot of food for thought in that we could apply some of those findings to recommendations we may have. Once again, everything ties back to racial inequities in our criminal justice system. And I know we have to keep repeating that is our goal, to address these inequities. So without any further ado, I think we have a presentation from New Jersey, who left the cash bail system and 3 years ago, I believe. But Natalia, are you going to cue that up or?
Yeah, Ellen's gonna get it going. She was hoping to join us live, but couldn't, so she was kind enough to record something. So just bear with us for a moment while Ellen gets it going.
Great, thanks.
Hello, everybody. My name is Claudia Dimitro. I'm a Deputy Attorney General at the New Jersey Attorney General's Office, specifically in the Division of Criminal Justice within the AG's office. And I'm excited to talk to you all about New Jersey's bail reform and general pretrial justice reform. I'm sharing my contact information, so please feel free to reach out to me with any questions or in any way I can be of assistance on this. I've worked on our bail reform since before it began, and I'm very passionate about sharing our experience, so I'd be happy to do so. I'm going to be talking about bail reform and also really pretrial justice reform, because we have also a speedy trial component of our bail reform. Our Chief Justice calls it criminal justice reform, if you see it anywhere, but really we're talking about pretrial justice reform. So it started back in 2012. The New Jersey Drug Policy Alliance issued a report examining New Jersey's county jail population and found that 12% of inmates in county jail pre-trial were there because they could not post a bail of $2,500 or less. So this gross inequities based on a small amount of money started the conversation. This report started the conversation on reforming. The Supreme Court got behind it and issued a joint committee report with members from across the criminal justice spectrum. And there was basically some agreement amongst the prosecutors and the public defender to remove monetary bail to allow for preventative detention in those cases that are warranted, and I'll discuss that process, but that those people are not able to get out based just on money. And yet, on the other side, people can be released right away or very soon without having to post any money whatsoever. So we had support from the very beginning from partners, from the prosecutors, the Attorney General, the public defender, and the ACLU. The biggest impediment to starting bail reform in New Jersey was the Constitution. Our New Jersey Constitution had a right to bail. So unlike the federal Constitution, which just has a right to not have excessive bail, we had a right to have bail posted. So that had to be removed, and it was by ballot referendum of the voters of New Jersey to remove that part of the Constitution. That allowed our mostly Democratic legislature to pass a statute that was signed by then Governor Republican Chris Christie. So it's been a very bipartisan effort from the beginning, which that statute set up the process for pretrial detention, basically removed most of the bail in the procedures. There is an ability to post bail in New Jersey, monetary bail, and that does occur in a few small cases, but mostly removed it from the calculation, and also set up a statutory speedy trial right for those defendants who are detained pretrial. So there was no speedy trial statute in New Jersey prior to this statute. There was only obviously the constitutional right to a speedy trial in the Sixth Amendment. So this statute now says that anyone who is detained pretrial, there is a literal clock ticking by which the prosecutor must indict and start the trial, or if not, the defendant will be released if it doesn't occur. The next thing that occurred was our Attorney General issued a directive. Our Attorney General in New Jersey has very strong power by statute to set uniform procedures that all law enforcement must follow in New Jersey. So any directive or guideline that the AG issues, and he or she issues them often, every police officer, every prosecutor must follow them and has to follow them. So the AG issued about 100-page, a long, comprehensive directive that's on public in our website that set forth all the procedures that the police must follow when putting people on summons or warrants, all the procedures prosecutors must follow when deciding whether to file for detention and deciding whether to file to revoke a defendant's release. And it sets a framework sort of when to file, when not to file, and how to decide to do the two. So we have uniform procedures that are followed in every county on bail reform. Likewise, we have a one public defender who controls all the public defenders in each county in New Jersey, and a unified court system that our Chief Justice and the Administrative Office of the Courts control all of the courts in New Jersey. So between all of those parties and the support of the ACLU, you have very uniform procedures on bail reform in New Jersey, and you also had support from pretty much everybody to let this happen and really to set us up for success. I believe that's a big part of our success, is having this, not have a patchwork system, but one system across the state. And I know that's something that a lot of states don't have, and that's something to keep in mind. So because of the support from the different partners, there was no challenge by the ACLU or the defense bar of our system. The only litigation challenge was from the bail bondsmen themselves. As our Chief Justice has said, there's really been no way to have a fruitful discussion with them, so they've not been involved in the process. They have lost their challenge, though, in the Third Circuit trying to challenge our system. So the procedure that was set up by the statute started in 2017. That's when we went live. And the universe of defendants who were covered under this new system are those who were charged with an indictable crime, is what we call it, really, in other words, felonies, or domestic violence, disorderly persons offense, is what we call it, or misdemeanors. So felonies and DV misdemeanors are considered eligible for this new system. Other lower offenses are in the municipal courts and not part of the system. So anyone who's an eligible defendant when charged by police, the police can put them on either a summons or a warrant, either put them on a summons or apply for a complaint warrant. And that's a very important distinction because by statute, defendants who were charged on a summons are released immediately without any conditions. So just released on their own recognizance, ROR, and provide a new court date. If police, though, decide to put the person on the charges on a warrant, the defendant must, by statute, has to be committed to the county jail and will be there for about 1 to 2 days, max 48 hours, to wait for their first appearance. And at their first appearance, if a prosecutor has not filed for the person to be detained, they'll be released by the judge with some sort of conditions. If during that time period the prosecutor does file for detention, then a detention hearing will be scheduled a few days out from that date. So that distinction between warrant and summons is very important. Police make it right up front, and a big part of what our directive says in discouraging police to issue warrants and really encouraging summons, encouraging more people to be released immediately, and that has borne out. So in 2014, our reform, about 54% of our complaints were complaint summons. That has gone up to almost 70% in 2018. And likewise, the number of warrants went down from 46% in 2014 to about 30%. So we've greatly reduced the number of warrants and increased the number of summons and allowed for a lot more people to be just released automatically in New Jersey. If at the detention hearing, if there is one, if the prosecutor files for detention, and at the hearing, the standard is the judge has to find, if the judge finds no combination of conditions or monitoring will reasonably assure the safety of the community, that defendant will appear in court, and that he or she will not obstruct the criminal justice process, the defendant will be detained pre-trial and will be subject to the speedy trial provisions. So if there's no combination of conditions that will assure those three goals, safety, the appearance for court, and no obstruction of the process, he or she will be detained. If there is a number of conditions that will ensure it, those conditions will be imposed and the person will be released. The rate of pretrial detention in New Jersey is very low. So for all of those defendants in this universe of cases I've talked about, those eligible defendants, only 5.7% of them were detained in New Jersey last year, 2019. We also have a PSA, public safety assessment, and a risk assessment that helps the different people in the criminal justice system make the decisions of whether to detain or release somebody. So our PSA was developed by the Laura and John Arnold Foundation, and it measures a person's risk based on objective, really just court information. So there's no interview or anything like that. And it's based on a defendant's criminal record, the current charge against the defendant, his or her court appearance history, and their age. It's run by law enforcement, and law enforcement at first uses it in deciding whether to put someone on a warrant or a summons, and then it is rerun again by the court just before a detention hearing, if there is one, in helping the court make that final decision whether to release a person. It is not, the PSA is not the final decision. It is the judge that makes the final decision after argument by the state and by the defense. There is the score. The PSA works on a score from 1 to 6 for whether a person is likely to have new criminal activity, 1 being the lowest risk, 6 being the highest. And then again, 1 to 6 on the person's likelihood of appearance. It's a failure to appear score, again, 1 to 6. There's also a flag, a violence flag, that's either on or off, up or down, whether there's a likelihood that the person will commit a new violent crime. The Supreme Court had hired independent researchers to basically validate the PSA since it has been enacted. So using those actual New Jersey cases we've had since 2017, they've tracked those cases from the beginning to see whether the defendants actually did commit new crimes, if at all, and did appear, and found that it has been predictive of the defendants. I'm going to send to you some of the reports the court has issued on all of this data, so you can look for it yourself. But otherwise, we found that recidivism while on pretrial release and court appearance have been largely the same pre and post reform. So defendants, the percentages of times they were charged with an indictable offense while on release has been basically 12-13% before and after the removal of monetary bail, and the times where defendants have showed up in court, percentage about 90% across the board, pre and post. So that hasn't changed with removing monetary bail. New offenses and appearance amounts have not changed. What has changed, and that's the big part of our success, is the number of inmates in county jail has declined drastically. There was 15,000 inmates in custody in 2012, and last year there was just under 8,000. So almost half have been of our jail population has been reduced. And we've also found that those people who are in jail are there for more serious offenses. So we have the most serious people, most serious charges of defendants in jail, and the number of people who are there for not serious offenses, they're not there. Sorry, there are people who are not charged with serious offenses are not in there for the most part. We are really proud of the system that we've created, and we do believe it's fairer across the board and more equitable. And that's the good news. The sort of bad news, right? This is a racial equity task force that I'm talking to you in the context of, and the sort of bad news has been again about racial equity. So although our jail population is greatly diminished, the makeup, the percentage of those in jail is based on race is largely the same from before reform and after reform. So although we have about 14% Black people in New Jersey, the percentage of Black people in jail is 55%, and that was before and after reform. So although we've greatly reduced the number of people who are sitting in jail pre-trial, we still have racial inequity in our jails. And so that's something that our court has identified as a way to improve. And obviously a big concern for all of us. So we'll be looking to see how we can fix that problem. But along the way, we are proud of the reforms we have made. And we think we are a model for really the best in the nation as far as removing monetary bail. Again, please reach out to me. There's a lot more I would love to say to you, but short amount of time that I have. But please reach out and ask any questions that I may help you with. And I look forward to seeing how North Carolina can be the next step in bail reform. Good luck and have a good day.
So I know we don't have the benefit of being able to ask Claudia questions, but if people do have questions that you'd like me to pass along to her, just email me and I can send those all at the same time and get answers for all of you. And before we turn to Professor Smith, we also asked Jasmine, who you all know, to speak for just a few minutes on North Carolina's bail roundtable and some of the lessons learned there.
Thank you, Natalia. Thanks to Claudia from the New Jersey AG's office for participating. We actually first met last year at a national convening for AG staff who were working on various criminal justice reform issues, and she was presenting about New Jersey and I was presenting about North Carolina, which I'm going to tell you a little bit about now because I've been asked to speak briefly about our bail reform initiatives in the AG's office. When we first started looking into this issue a few years ago, one of the first things that we did after understanding the legal framework around North Carolina's pretrial system was meet with folks like Caitlin and Sonia, who you heard from last week, about their pretrial services programs. And also between that and understanding about the legal framework and particularly that there already was a statutory preference against financial conditions of release in 15534, and all of this innovative work that was going on in North Carolina, we decided that one way we could be helpful was to try to elevate both of those things. And so we held a roundtable in January of 2019 with essentially the top 18 largest counties in North Carolina, with the primary system actors at the local and state level. So the senior resident superior court judge, the chief district court judge, the sheriff, the district attorney, the public defender or local criminal defense attorney if there wasn't a public defender, the clerk of court, the chief magistrate, and the county manager or someone from the county manager's office. And so all of these people from each one of those 18 counties was invited. We partnered with Jesse Smith, who was our initial and primary presenter as a statewide expert on this issue. And our goal was to educate stakeholders about the features of an effective pretrial system and the dangers and unfairness of unnecessary pretrial detention. There were presentations from various other stakeholders like Christy Puckett Williams, who was a directly impacted person from the bail system and who the task force has heard from both during the listening sessions and during the public comment sessions. We heard from DA Woodall, who's on this work group, who speaks very eloquently about stakeholders working together to advance pretrial justice. We have provided some of the materials that were provided at the each roundtable in your working group folder, so we can get those to you if you're interested in those. And some of those materials included things like implementation ideas, which Jesse is going to talk about in just a moment. At the end of each day, the 18 counties broke up into work sessions where they could identify areas for reform within their jurisdiction, and they were asked to identify a coordinator for their work. Some of the most popular reforms were things like what you've already decided to do: first appearances for in-custody misdemeanors, citation in lieu of arrest. They were also very interested in revising bond policies to require things like written reasons for secured bond. And there was a lot of interest in pretrial services to improve pretrial outcomes. We received really positive reviews from this event and so decided to continue the effort across the state. And so had a roundtable in Wilson in June of 2019, and in Wilmington in the fall of 2019, and then in Winston-Salem in February of this year. The pandemic has interrupted our plans for the final roundtable, which was going to be with the Western counties. But we are particularly interested in how to proceed with that event, hopefully at some point when we are free to do so, based on what this task force comes up with around the issue of bail. I'd say there are three primary lessons that we learned from this experience, aside from the many logistical things that we learned. The first is that, and Jesse has said this many times, many stakeholders are very interested in this issue. If they're not moved by the justice and racial equity case for reform, then they're moved by the fiscal issues and the need for space in the jail, as you heard from Sonia last week. And if not that, then the fact that financial conditions of release and unnecessary detention actually hurt public safety, counter to what people might believe, both because dangerous but wealthy people can get out, but also because data shows that people who are detained pre-trial are more likely to be engaged in criminal activity in the future because of things like losing their job. The second lesson we learned is that while people are interested in a reform, they often need technical assistance to implement it. We were really excited that after the roundtables, attendees did start to implement some changes, and that new jurisdictions started working with Jessie to become new pilot projects with her innovation lab. But we also knew that it would be a slow, if hopefully steady process to achieve reform. And at the start of the pandemic, we were just gearing up to start to partner with Jessie on expanding the number of jurisdictions that we worked with on this sort of next step work. And third, related, rural jurisdictions, which you've heard some about, have system and resource barriers to implementing what would be seen as low cost or low hanging fruit things, such as first appearances with counsel because of a lack of judges or a lack of a public defender's office. So I'd say in my view that this series has been very effective with bringing the educational and culture change work that is necessary for pretrial work in North Carolina. But I'd also say that it is time for some statewide support of reform, particularly with regard to providing effective procedural protections, providing counsel, ability to pay tools, and funding for pretrial services where the county cannot or will not. So you'll hear from Jessie about sort of the full spectrum of things that we could talk about and consider. But I think it's really important that we consider not only what we should do, but how we can get it done in North Carolina. Attorney General Stein, is there anything you want to add about our work?
You did a great job summarizing it. And it's a series, it's something we've been working on for a year and a half, 2 years now. It is an area of this work of revisiting the criminal justice system where we can have an impact on literally thousands of people, because there are people in our jails who are there simply because they are too poor to be able to pay their bail. And when we detain people before trial, it should be because they pose a risk to society, not because they don't have enough money in their bank account. And so I think this is an issue that is very ripe for you all to give consideration. We have a whole series of ideas that we've developed over the course of meeting with the groups, the state, the counties that are really advanced on this issue. But Jessie's done great work in the western part of the state where they just simply don't have the same resources. And there are things that can be done in low wealth counties too, and urge you all to consider them. You know, the law says that people should not be detained with financial conditions unless they pose a risk to public safety, to injuring somebody or a witness, or a risk to fail to appear. And maybe one thing y'all need to do is take a hard look at what charges, there are certain misdemeanor charges where we should never be detaining people. Like, just maybe have a line in the sand, like below misdemeanors of this level or below, there should be no financial condition. Just issue them a citation, tell them to show up when it's time. So I hope that you all tackle this issue. It's an important issue. The reasons are people's liberty interest is about the most important thing we've got. And these are folks who have not been convicted of the crime for which they've been arrested. They've been arrested, which means that there needs to be a reason for why we would impinge upon their liberty. There's a huge issue, Commissioner Smith, to county budgets. Locking up all these people costs a lot of money. I mean, it's on over $100 a day for the typical county in North Carolina. And if you use some kind of alternative methods of ensuring compliance with people appearing up for the court date, it's a heck of a lot cheaper on county budgets. And so your taxpayers will love it. And then the public, all we want to do is be safe. We don't want people committing crime. And when you realize that people who are detained for periods of time before trial, every day after that third day makes it more likely they will commit a future crime. How's that for counterintuitive? We're supposed to be locking people up before their trial because we want to be safer, but it actually makes it more likely they'll commit more crime, because when you're locked up, you lose your job. You lose your job, you lose your house. You lose your job, you lose your car. You're in jail, you could lose your kid. Like, all these things have huge ramifications. And so I get on my soapbox, that's it. Good luck, figure it all out, tell us what to do.
Thank you. Natalia, I'm all set. I guess I turn it over to Jessie to tell us what we should do. She's not telling us what we should do. She's giving us options.
Thank you. Or otherwise, you'll just get me fired. Really.
Yes. Options.
I'm going to go ahead and try to screen share with you. Are you seeing my PowerPoint screen? Yeah, great. Okay, so I have about 20 minutes and I was asked to talk about two things. First is to talk about the Alamance County litigation and the lessons that it holds for bail reform in North Carolina. And second, to sort of set the table of the bail reform options that that you could consider. Some you've already made recommendations on, but then the full range of other options that Jasmine mentioned. And again, on that second test, I'm not advocating for you to do anything. Of course, the School of Government faculty are nonpartisan and non-advocacy. I'm trying to help you understand what your options are. We're a small group, so I certainly hope that you will interrupt me at any time. Let's see, bear with me for just a minute. I am trying to get the right, there we go. Trying to get the right screen up so I can control my PowerPoint. So I want to start with the Alamance County litigation. And basically what happened is in November of 2019, two organizations, the Civil Rights Corps, which has been litigating successfully bail issues nationwide for a while, co-counseled with the North Carolina ACLU and on behalf of plaintiffs, filed a federal class action lawsuit challenging Alamance County's money-based bail system. Now that system really doesn't differ all that much from many of the systems in place around North Carolina. And the challenge asserted various violations of the plaintiff's constitutional rights to equal protection, due process, right to counsel. And all the judicial defendants and the sheriff were named in the lawsuit. The parties entered into a consent order in May of this year. Essentially, the defendants conceded that there were problems in the local bail system and agreed to radically revamp that system. And I think the reason why it's maybe important for your consideration is that because the parties agreed as part of that consent order that the changes to the Alamance system that were implemented July 1st actually kind of provide a model for a constitutionally compliant bail system. So I want to talk briefly about not all of the features of the system, but some of the key features of the system. And the first thing is something that both the Attorney General and Jasmine both mentioned is the policy incorporates the statutory presumption against secured bonds. Our statute says that written promise, custody release, or unsecured bond must be imposed unless the statutory risk factors are present. What are those factors? Danger of injury to a person, non-appearance, or interference with the criminal proceeding. So that's in the bail policy now. Another thing that's in the new policy is it creates a presumption against using secured bonds in low-level misdemeanor cases, specifically if it's a class 1, 2, or 3 misdemeanor. So not A1s. A1s are the highest class of misdemeanor, things like assault on a female, they tend to be more violent offenses. If it's a class 1, 2, or 3, the judicial official must impose something other than a secured bond unless specifically listed factors are present, like it involved a firearm and the like. Another thing is the statute provides that if the most serious offense is a class 3 misdemeanor, that's the lowest level misdemeanor we have in North Carolina, and based on the person's conviction record, they couldn't get active time if convicted, they can't get a money bond unless there's documented danger of injury to a person. So essentially, if you can't get a sentence when you're convicted, you can't be detained pretrial on a money bond unless there's a danger of injury to a person.
Jesse, can I ask, why does it say certain class 3 misdemeanors?
Because it says certain class 3 misdemeanors because it applies for all. So class 3 misdemeanors when the individual, based on their prior conviction record, could not receive an active sentence. So it actually requires some calculation on the magistrate's part that they're actually weren't used to doing.
So if they have 5 prior class 3
misdemeanors. Yeah, it doesn't exclude misdemeanors. I should have said misdemeanor defendants or certain defendants charged with class 3 misdemeanors. Thanks for that clarification. There's also a presumption for non-monetary release. So we've got these forms that the non-monetary release are written promise and custody. The monetary release are unsecured and secured bonds. The new policy has a preference always for a written promise for custody over any kind of monetary form of release. There's also a limitation on electronic house arrest as a release condition. Only a judge can do it. There have to be extraordinary circumstances, and importantly, costs can't be shifted to defendants. That's a big area of controversy in this field generally in the nation, cost shifting to defendants for these supervision strategies. Another thing in the consent order is that if a secured bond is required in the case, the judge has to make an individualized finding that the person can pay or that detention is necessary. Either that they can pay or detention is necessary, and the standard is clear and convincing evidence. There's also a new structured decision-making flowchart process to be used. It incorporates these provisions and others. It's kind of based on the reforms that went into effect in Judicial District 30B and then in Forsyth and District 2, which were the first jurisdictions to adopt a sort of flowchart process. It's modeled on that, but it's tailored to this specific jurisdiction. It also requires that when a secured bond is imposed, there have to be written findings. And it's operationalized with a new form that's created to document the reasons for imposition of the secured bond. Another thing that's new in the policy is while it does contain bond tables, they're no longer the first step in the analysis. They're the last step in the analysis. The decision maker has to go apply the presumptions and go through the flowchart process, and only if they arrive at the end where a secured bond is allowed would they look to the bond tables, which contain maximum amounts, which they can exceed, but only in extraordinary circumstances, and if the reasons are documented. Something really important in the policy is the ability to pay provisions. Ability to pay now has to be considered both as to the type of condition, so written promise versus financial condition, but also as to the amount of the bond that's imposed. To operationalize this, the consent order and the policy create a set of rebuttable presumptions, essentially for indigency with respect to bail. And they sort of fall into two baskets. The first basket is a broad one that basically says there's a rebuttable presumption that people can't pay more than 2% of their monthly income. So for someone that earns $36,000 a year, that's $60. It's a really low threshold. It's an aggressive threshold about ability to pay secured bond. That's the first type of rebuttable presumption. The other type of rebuttable presumption is that the consent order and the policy provides that if one of 7 listed circumstances apply, there's a presumption the person can't pay any money bail. And those things include eligible for counsel, full-time student, getting public assistance, and factors like that. They're spelled out in the consent order and in the policy. Now, they are rebuttable presumptions, but there are only 4 ways under the new policy that those presumptions can be rebutted. So pretty aggressive presumptions and a limited set of facts that can be considered in terms of rebuttal evidence that look at things like, does the person have substantial assets on hand? And there's specific dollar amounts and thresholds that are included to assist decision makers in figuring that out. Also, these ability to pay decisions have to be documented. They're on the new secured bond form that was created. The other thing that's new in Alamance is they now have first appearances for in-custody defendants. Specifically, people who are held pretrial have to be brought before a judge within 48 hours of arrest or at the next session of court, whichever is earlier for an appropriate proceeding. There are some other details to that. There are quite aggressive notice requirements that have to be provided by magistrates and judges in advance of and at the proceedings so that people understand what's to be considered and what their rights are. Additionally, they have a right to counsel. Now, Alamance is one of those counties that doesn't have a public defender. Counsel has to be provided at the state expense, and that's being done through a contract system through Indigent Defense Services, a similar sort of model that was used in some of our pilot projects. The defendant also has to have an opportunity to consult with counsel prior to the proceeding. Now, at the proceeding, there are requirements about what's supposed to happen at that first appearance. It's not just a proceeding where boxes are checked. The individual has the right to be heard, to present evidence, to confront evidence, and the like, for it to be a more meaningful proceeding than what you often see if you've observed first appearances. So that's a very quick summary, but those are the major features of the Alamance system. And again, there are folks who are considering them to be sort of the blueprint for what a constitutional bail system looks like. So, and I believe my recent blog post has been circulated to you, which outlines all of these in more detail. The second thing I was asked to talk about is sort of lay the table for your options for the discussion for the rest of your session. But before I do that, any questions about the Alamance case?
I'm just curious, Jesse, and I mean, that's overwhelming reform.
Yes.
That the evaluation of it, like first appearances, you know, we in Durham used to do first appearances, and usually within an hour you would have 40 people in and out.
Yeah.
This will require a lot more court time.
Yes.
Any feedback since May or the evaluation of it?
So we're not engaged in an evaluation in that particular project. I believe that there's some monitoring going on by the parties. I can tell you that in the first project we worked with in 30B, where they started doing first appearances, there was a lot of friction over that, because they started doing new first appearances at 2 o'clock in the afternoon so that everybody would know when they were. There would be time to get the defendants there, and they were represented by counsel, and the district court judges felt like it was taking too long. Yeah. You know, well, in Alamance, it's constitutionally, it's required, so it's really not an option. But yeah, that is an issue, and I know there was some discussion about getting some emergency judge help. So there would be maybe an emergency judge who would just basically handle those first appearances at 2 o'clock. I'm working in Judicial District 2. They implemented new first appearances effective January 1st. They haven't reported the same kind of problems. Of course, their caseloads are different. They're, you know, more rural, smaller, a little bit smaller caseloads, but in any event, that is an issue. That most certainly is an issue, as is the cost of providing lawyers.
Do we know the jail population reduction from, well, COVID changes?
Yeah, I have all of that data, and certainly could supply it to you, because we actually are monitoring jail population reductions. In Judicial District 30B, there wasn't a huge overall reduction in the jail population, but there was a big reduction in the time people spent. In other words, there were way more stays of like a day or two as opposed to 3 days or longer. So it was really shortening that period. And as the Attorney General mentioned, we know that a lot of those consequences of pretrial detention kick in after, you know, a few days. So if you can get people in and out, that's generally thought to be a good thing on the lower level offenses. But again, in the projects that we're evaluating now in 6 counties, we are looking at jail population numbers. So in terms of the options, there are kind of 2 sort of preliminary things, or maybe they come at the end. They either come at the beginning or the end, but it is, you know, the sort of the what and the how. And the what is like, what are the options you're going to consider? And then the how is, how are you going to do it? And that's the implementation mechanism. Is it going to be by a Supreme Court rule? Are you going to rely on local action and go, you know, county by county through 100 North Carolina counties? Are you talking about legislation? And there are pluses and minuses to all of these routes. Sometimes some of them are easy, sometimes some of them are harder. It's an important issue, and I understand it's going to be part of your conversation today. I just wanted to flag it right now to be thinking about the what as we, the hows, as we talk about the whats. And I know that you have already considered several options. I know that you've already made a recommendation regarding first appearances with the right to counsel. I haven't seen your recommendation. I don't think that you guys have dealt with who pays for counsel, notice for first appearance, defendants' rights like to confront evidence and the things that were part of the Alamance County litigation. So that may or may not be something that you want to revisit. You also made a recommendation regarding citation in lieu of arrest. I haven't seen the details of it, but I'm just sort of noting that you have already addressed these, at least the first two. There may be some things to expand on if you choose to. But there have been a lot of other options that have been raised in meetings and in communications with folks that are involved in the task force. And what I want to do, this is the table setting for what comes next in your meeting, which is, do you want to make recommendations in any of these additional areas? So I'm going to go through them again. Stop me. I'm going to try to just kind of give you a snippet. If I'm not giving you enough so that you feel you can talk to the issue, stop me and we can expand. The first option is, we saw this in the Alamance litigation, is requiring adherence to the statutory mandate that written promise, unsecured and custody release must be imposed unless those forms of release won't assure appearance, protect against injury, and protect the criminal processes. It's not in all of the local bail policies, and even when it's in some of them, it's not operationalized, meaning it's words in the policy, but it's not part of the actual decision-making tool that's used. But this is a sort of a powerful provision, pre-existing provision that's in the statute, but is not, life is not being fully breathed into that provision in most jurisdictions. Another option that folks have talked about is restricting the use or creating presumptions regarding financial conditions. The Attorney General mentioned restricting the use. You know, that perhaps there are some classes of misdemeanors where, at least in the first instance, you can't impose a bond. Now, you may want to have a bond if those people never show up to court, or some kind of sanction on them if they never show up to court, because you've made something a low-level offense criminal. You certainly want them to appear and answer charges, but that's one potential option. The other option is creating presumptions, the kinds of things we saw in the Alamance County policy. There are other presumptions that you could create, presumptions in favor of non-monetary conditions, presumptions for those low-level offenses, and the like. Ability to pay. We talked about how this was operationalized very aggressively in the Alamance County litigation, with the presumptions of indigency, essentially, with the limited rebuttal evidence. That's not the only way ability to pay could be done, but this is an important protection that folks are talking about. Another thing that people are talking about is detention bond hearings for people who are detained pretrial. Essentially what that means is this, that anyone who's detained pretrial, whether it's because they can't afford to pay their $2,000 bond, or because a judge has found that person to be too dangerous to be released, gets a constitutionally compliant detention bond hearing, which is a full-blown hearing with counsel, with evidence, where the judge has to make a clear and convincing finding that no other less restrictive condition can meet the statutory purposes of bail. That would be a significant change, but it's already one that's being implemented. I work with Forsyth on reforms. They started them in January. They are regularly doing detention bond hearings. When the prosecutor is arguing the person is too dangerous to be released, there's a detention bond hearing where evidence is presented and the judge makes findings.
When is that held? Is that the first appearance?
No, it's typically held after, because generally the lawyer needs a little bit more time, but it happens very quickly. It happens very quickly. So there's the first appearance, and if the prosecutor is asking for a detention bond hearing, it gets scheduled quite quickly, and unless there's agreement by defense counsel for it to be continued. And that's pretty typical when you look at statutes like New Jersey and other, and I've if you're interested in detention bond hearings, I have a very lengthy paper on this where I present several models of detention bond hearings. And typically what happens is they happen very quickly after that first judicial review. There's a time period typically when they have to occur, and that time period can't be extended unless there's agreement by the defense counsel on that. Another thing, and you've already talked about this, you heard from folks last time about appropriate pretrial services and supervision. Not all jurisdictions have this. This is currently funded at the county level. Some jurisdictions have moved forward to provide pretrial services at the jurisdiction level, like in the District of Columbia. In places like Virginia, they actually have regional pretrial services. I included the word appropriate here, and I included that for a reason. There are lots of things that people are sometimes inclined to do as pretrial supervision that aren't supported by the evidence. Drug testing is a really common condition that gets imposed. The evidence is really very limited that it actually is effective in terms of achieving pretrial objectives. We have a briefing paper on that topic as well if it's of interest. Data collection and reporting. We've talked about challenges in criminal justice data. Today, we cannot say how many people are incarcerated pre-trial in North Carolina jails, and we cannot say what the racial makeup of those people are. We don't know bond amounts for people who are detained pre-trial or who receive bond, and we don't know how those bond amounts or whether those bond amounts vary based on individuals' race. We don't know how long people have been sitting in jail in North Carolina, and we don't know if those wait times vary by race. We don't know how many people are being held on bonds of $2,000 or less or $500 or less, and whether those numbers vary by race. Those kinds of studies that are done often are a predicate to reform. That's exactly what happened in New Jersey, and you just heard it from the speaker. What precipitated their effort was a statewide study of jail populations that documented particularly large numbers of people sitting in jail on small amounts of money. We also know from studies in other jurisdictions that there often are very big racial disparities in pretrial systems.
Can I ask a question?
Yes, of course. You're the boss.
Briefly talked about there is a monthly reporting requirement by our local jails to DHHS.
Yes.
Is any of this information that, you know, the racial makeup, how long are they in, what the amount is, that's not included?
It is not included. And as a matter of fact, I mentioned when we were, at some point, I believe I mentioned, we actually did an information request and have gotten banker's boxes of the individual record submissions. So we've been able to look at them. They include overall jail population. They don't break jail population down by who's serving a sentence, who's on an ICE hold, who's pretrial, and other reasons. They do have racial information of who's in jail. We don't know what they're for, and we're actually compiling that and are going to be updating our jail data reports as soon as that's done. It probably will be next month. It's an arduous process to go through every month's data for every single jail, you know, over the course of a year. So the short answer to your question is statewide, we just don't know. But again, that is, it's in the administrative code. There's a form that DHHS provides that may be an avenue y'all want to look at about changing that reporting requirement that the jails have. I would say already there's a problem. We're noticing lots of gaps, some jails that do not report and some jails that don't report consistently. So that may be a sort of a twin issue that you want to talk about. And again,
about a couple of more minutes.
Yep. Okay. So summons in lieu of arrest, that's sort of the twin to citation in lieu of arrest, which you've already acted on. I previously showed you the data. It's not used. It's used. Individuals don't get brought before the magistrate and they don't get bail. Enhanced court date reminder systems. We have one in North Carolina. It has significant limitations. It's not widely used. Some exploration of how to enhance that would help. Studies show this is a great low-cost option to increase appearance rates and avoid orders for arrest for FTAs and incarceration, particularly on low offenses.
Yes, let me interrupt there just
Yes.
for a second, Josh. This is something that the AOC is working on. And Jasmine, I don't know if you have the latest update on it, but you know, we all get texts now from our dentists and doctors to remind us to come to our appointments because they're tired of getting burned by people forgetting their appointments and losing out on revenue. And people just need reminders. And most everyone has a cell phone in their pocket, not everybody, but a lot of people do. And so having some kind of texting system, I think, is a really, like Jesse said, a low-hanging fruit way. Jasmine, is there any update on AOC on this? if Jasmine's listening.
Yes, I'm here. Yes, it's live, but what Jesse's identifying is that there are ways that we could improve it and change the system to get more people engaged in the system.
Greater.
I think that was the point.
Yeah, and also have it, the way it works now is if you sign up in district court, you get bumped, you have to re-sign up when your case gets bound over to Superior Court. Like, it's an easy way to fix that, that type of system.
Okay, thanks.
So risk assessment instruments and structured decision-making, whether it's an actuarial risk assessment tool or whether it's a sort of flowchart process like 8 other jurisdictions have already done, plus now Alamance is doing. This is a way to really build into the process the existing statutory rules and other types of processes like ability to pay and other things, bring them front and center to the decision makers. New procedures on addressing non-appearances. I'm working with the jurisdiction now that's going live October 1st with an aggressive new policy to change the default from being an order for arrest for a first missed court date in low-level cases to be certain alternatives. So that's another option. Review of jail rolls, you've heard about that. It can be a jail navigator, it can be a judge, just looking at the jail rolls along with the prosecutor, defenders, and others. Pre-charge diversion is another thing that links into bail, because if they don't get charged in the system, they don't get brought to the magistrate and get bail. Criminal justice councils, just another way to bring people together to formalize a process to chip away at criminal justice issues. And of course, there's always the issue of training for folks that's on the table. So that's the table that I was asked to sort of set with the range of options that you might want to consider in your remaining time. And Representative Morey, I don't know if you want me to leave this up or take it off. I'll do whatever you want depending on how you're going to proceed. You're on mute.
If we click back to it when we need it, I copied it down. Hopefully everyone took notes. Okay, you packed it in, Jesse. Thank you. That is a lot to look at. And then also, I keep going back to North Carolina and our unified court system. And we have always the tension of counties that can afford the robust pretrial, those that can't, and how do we make this equitable across our state, keeping this unified court system concept at the front of our mind. And maybe that shouldn't be an issue to think about now, but I know I ran into issues with the prior director of the AOC when he, if one court had drug courts or mental health courts and not everyone did, or family courts, and nobody should have them, which I think put us back from serving the people who needed the help the most. But let's open this up for discussion. I know it's been a lot to listen to, and I think Commissioner Smith had to leave, but we do have Senator Mohammed and Tara, and jump in.
Professor Smith, thank you so much for your presentation, and thank you, Representative Morey, for the opportunity. I wanted to hear a little bit more about those detention bond hearings, because if we do recommend a lot more reforms this fall, or just not using money bail, especially with low-level offenses, I'm still concerned at the end of the day for A1 misdemeanors or felonies. And what I envision is using something like we use in juvenile court, Representative Morey, with detention hearings, how you've got to have them after that first hearing, within 10 days, I believe, the review hearing. It's been a little while since I've been in juvenile court. But that way, we address speedy trial issues, even for much more serious cases, and we can still continue to look at folks being in custody and the consequences of it if folks are continuously brought to court. And at the end of the day, if a defendant doesn't feel like he may be released based on circumstances, just like in juvenile court, could choose to waive that hearing. So I'm just trying to see if you know if there's any other states that are doing something similar to that with serious charges, or.
Yeah,
anything
so
like that?
so I'm going to just really super quickly share something with you, and I'll send it to Representative Morey. I have a very lengthy paper that's posted online on preventative pretrial detention in North Carolina that talks about detention bond hearings and goes through all of the sort of procedural issues that arise in them, including the right to a prompt detention hearing, and the constitutional requirements. Specifically, Salerno U.S. Supreme Court has said they have to be prompt. And included in this paper, I have got 4 models of preventative detention from the District of Columbia, New Jersey, New Mexico, federal statute, and then the ABA standard. So I can supply all that to you, and it gives you a good model for what you would write in about the requirements on preventative detention.
All right.
I'll send that along.
Appreciate it. For me, Representative Moore, I don't know if you want to get into the discussion about what type of recommendations we want to make today, because I know we're looking at other recommendations that we've previously made as well. So it depends on how much time we actually have. Do you want to get into the pretrial bail practices right now?
Let's do it at the end. Natalia will go all over the language, what we've already recommended, so we can put that off the table. But yeah, that's what this discussion is for now.
I mean, for me, looking at the constitutional understandings that Professor Smith talked about, looking at this Alamance County consent order, I think all those recommendations are absolutely critical. But I also do agree that there are certain charges that we shouldn't have bond hearings at all. I mean, we don't necessarily need a presumption. So I would recommend for all, personally, I think for all misdemeanors, we shouldn't use money bail at all for those types of situations. But in general, we should always have the presumption against secured bonds in general, unless there's certain findings, just like Alamance talks about. I mean, I think that's a great way to just solve a lot of the issues. But if we can take everything that Professor Smith shared, especially in the Alamance County consent order, and made that part of our recommendation, I think that's a great step forward that solves a lot of these questions. The other thing I do want to recommend is with our pretrial services. I remember the representative from Orange County talked about how issues of transportation and childcare are never included in those reports, which could determine if the individual stays in custody or not, or is recommended release or not. That type of information, and also having a pretrial service where those in-person meetings are done by pretrial services to, assess this individual's abilities and finding out what's happening in their life and their circumstances. I think the representative from Mecklenburg County talked about, ever since we've implemented ours, 40%. A lot low-risk defendants that were held 2 to 3 days were almost 40% more likely to commit new crimes before their trial, just because they were held. So, I mean, I think if we can get that type of pretrial service recommendation for county-wide, I know it's a funding issue, because right now the counties would be stretched thin, but that's something that the legislature also needs to look at the end of the day.
Well, and if you're considerably cutting your jail detention staff, it's a reallocation of people.
Saving money. Attorney General Stein talked about $100 a day when folks are in custody. That's 2 to 3 days that they didn't have to be in there, but now they're a further threat to public safety because they were there. And the other thing, just real quick, I mean, I know Professor Smith also talked about ability to pay determinations being made as an issue. My thing is also, if you have the ability to pay to get out of jail and post a bond, but for whatever reason, if whatever happens, you end up losing your job because of these criminal charges, it becomes an ability to pay issue later on in the future because you might have lost your job or housing. So, I mean, that's part of the reason why I think that we should end cash bail, especially for all the misdemeanors.
Would you include in that A1 misdemeanors? Or, I mean, there's some exceptions if it's domestic violence or an A1 assault on law enforcement, or if it's the use of a firearm. I mean, would you see?
I'm supportive of those recommendations. If there's certain types of circumstances associated with it, then yeah, with those written findings that Professor Smith talked about, that our judges would have to make and magistrates would have to make.
Yeah. Thanks. Tara, what are your thoughts?
So I'm work to promote evidence-based reform. So obviously, I think one of the biggest problems that I see is just that we don't have the evidence. And in areas like Buncombe that have started gathering it, they've started self-correcting because they now see what they're practically doing. So the legislation that came before Senator Mohammed's committee about 5 times, the First Step Act was about mandatory minimums in drug trafficking, and somehow the part about the study to just collect what jails are just to study what they're collecting turned out to be the most controversial part. So I think we're that in itself showcases a problem to me.
And by the studies, Tara, are you talking like what Professor Smith was saying at the end, that we just don't have the data, who's being held, why they're being held, the racial to DHHS from the jails, or?
Yeah, just who's being held, why, if bond has been offered, and then just also access. So the data that is collected is all collected in CJ leads and prosecutors, and I think law enforcement have access to it, but defense attorneys and organizations like the School of Government don't, and that's, a real gap.
Right. Okay.
Representative Morey, so if we want to make a recommendation that there's no secured bonds for low-level misdemeanors, except with those exceptions for those A1 misdemeanors, for whatever reason, firearm, domestic violence. I still think that we should still make a preference for even those to have an unsecured bond or some other alternative. But with some of the much more serious felonies and violent felonies or felonies in general, I think what we should look at is what Professor Smith talked about, is detention bond hearings, to give those individuals opportunities to get those consistent hearings, so the prosecutor's aware, so attorneys aware, so they can figure out what's continuing to happen in this case, instead of these individuals who oftentimes are the folks who are sitting in jail because they have those felonies just pending. I don't know if that review hearing should be like we have in juvenile court, no more than 10 days, or it should be longer, but we should also provide in that recommendation that the defendant could waive, if they wanted to, that hearing. I think that'd be a good step with some of the much more serious charges.
Okay. Just from a point of discussion, I mean, I think if we go back, that the most obvious is we need to require adherence to our statute that mandates non-secured bonds. I mean, and I know Justice Earls has talked about that at one of our first task force meetings, but what are the consequences? It seems like there's no consequence if that is being ignored unless you have another lawsuit filed against a certain county. But that needs to be emphasized, and in compliance with all local judicial districts administrative orders signed by the senior resident and the chief district court judge, that has to be within, any bond policies are there. That's the tenet from where we start. I'm worried about prohibiting any cash bond on A1 misdemeanors. I think class 2 and 3, those should not have any cash bond requirements. Some of the ones, or the A1s, a presumption not to issue cash bond unless certain special findings are found. And then what do we do if someone has a history of failure to appears? I mean, does that change the scale on imposing a cash bond or not? It's a low level, it's a misdemeanor larceny, but then you check the criminal history, it's a level 3, history point, and failure to appear, failure to appear, failure to appear. Just the question.
Well, Representative, for me, I don't think, like I said, for the 1 through 3, for sure, I think we shouldn't have any type of secured bond recommendation on those at all. The A1s, again, that's a different question. But like you said, if we've got to figure out folks to adhere to the statutory preference for conditions other than a secure bond. I think that is absolutely a good start. And that's for all charges. So if we start there, we wouldn't have these other issues. But whether it's shoplifting, whether it's even a misdemeanor larceny, I don't see why we need to implement cash bail for those types of issues. Unless there is an issue where this individual doesn't come to court at all. And I guess that's where those PSA assessments, those public safety assessments would come into place based on this individual's history or not. I mean, that could be an exception. But then again, I just think about some of my clients who have severe mental health issues and different types of struggles who cannot get their court date right. Maybe we need to revamp our way of communication with expansion of our court date reminders. There's got to be a better system for those individuals, especially since it's low-level offenses. Because the majority of the folks that I know who don't show up to courts is usually because they have had life happen to them. It's not like they're necessarily avoiding court. It's they don't know where they're sleeping tomorrow, or they're struggling with substance abuse issues. If they were, of sane mind and well and thinking and understood the consequences of not showing up to court, they would come to court. But the majority of the folks that I've ever represented in those situations, they just weren't there to understand the consequences of it, and they just sat in jail cells again.
In Durham, I implemented a blue sheet that anyone that missed their court date, if they would come down to court, fill out a blue sheet, any reason why they missed their court date, simply they forgot, we gave them a pass, strike the FTA, reset it, and we put the blue sheet in the shuck. I think Kate Finhagen mentioned they're doing that in Orange County. I would probably sign on an average day 10 to 15 failure to appear order for arrest strikes. And if you multiply that by 5 days or plus a weekend, I mean, it was probably 50, 60 people we avoided being arrested and brought to court, and they came back for their court date for the most part. So, looking at something like that, we still have on our statute doubling the bond. If someone commits a new offense and they're out on bond, should that be something that there should be more judicial discretion rather than the magistrate automatically doubling the original bond? Jesse, you rolled your eyes. Is that changed?
Oh, I didn't mean, no, I didn't. I didn't mean to roll my eyes. I think I was just looking off to the side.
No.
Disrespect, no shade.
I mean, the mandatory doubling the bond.
So there's mandatory bond doubling for an FTA. The provision about new offense was changed to have it be permissive and not mandatory. If it's helpful, it might be helpful just as a framework to give folks to be thinking that I know a number of individuals that are working in this are starting to think about the fundamental decision is, should the person be released or detained? Because there is no persuasive evidence that a bond incentivizes appearance, right? If I pay a bondsman today, I'd lose that money forever, regardless of whether I appear in court or not. So if you're thinking about release or detain, it sort of simplifies the decision when you're thinking about classes of offenses. And of course, if you have supervision, you have an option in between, which is release with supervision, or detain. And then the question becomes, who should be in the universe of people? And I think this is the discussion that was just happening, who should be eligible for detention? And systems vary. And in that paper that I mentioned to you, I talk about that issue of what's the permissible net and how have other jurisdictions handled this. Serious violent felonies, rapes, murders, everyone would probably say, oh yeah, eligible for detention. Misdemeanor domestic violence, maybe a lot of people would say yes to that. Forcible trespass, I mean, those are, that's a class 1 misdemeanor, right? And so, but if you're thinking release or detain and sort of, I'll stop there, but sometimes that can help to focus on what's really happening pre-trial.
Great point. So if we go back to what was presented to us, and there was a list of a lot, but just starting, are we in agreement? And we'll have to run this by the other two who aren't with us today, but the requirement of the strict adherence to our statutory mandate on non-secure. Maybe beef it up with, for those that don't, there has to be some evaluation or auditing, random auditing or something. The second one, and I think we're recommending, or Tara's, your opinion, to restrict the use of money bond on class 1, 2, 3s, unless there are special findings of something else. Is that right, Senator?
Oh, sorry, Representative Moore. Yeah, for yes, restrict the use of the secured bond for class 1, 2, and 3. The only circumstances that I see it potentially is if this individual doesn't come to court at all. That's
So
the only time
if there are
with the
special findings of the use of a weapon or injury to others or repeated failure to come to courts.
I mean, I can see it with repeated failures, but I mean, even a simple assault, I'm not sure if we need to, how is the use of money going to ensure that they're going to come back to court, just like Professor Smith talked about at the end of the day. I mean, my thing is, again and again, how is using money going to make this individual come to court for a simple assault or for a second-degree trespass, even a breaking and entering? I mean, if it's a class 1 misdemeanor, they weren't going in there to steal anything. In my experience, oftentimes they're homeless or they went to go smoke some marijuana or something with younger kids to an abandoned home, and that's where they're at. And now they'd be sitting in jail because they don't have the money to get out. And they were originally breaking and entering into the home because they probably didn't have the money to find somewhere to sleep and be where they needed to be. Yeah. So, again, I just don't see any use of money when it comes to those class 1 to 3 especially. I can understand the additional exemptions for the A1 misdemeanors. But I don't know, Tara, Representative Moore. I mean, you're part of the team, Representative Moore.
Yeah. I just think in my experience, there are some occasions where there is a repeat offender on a class 1. If it's an assault, they don't come to court, and that there could be discretion for a judge to impose bond. The general rule is not, but.
As long as there's a general rule not to do it. Right?
One of many, so.
I think that's the best, as long as we have a general rule that where you shouldn't immediately jump to that.
Right. So
even though we have that, it goes back to our first recommendation.
Right. So unless there's special aggravated findings of failure to appear or a threat or danger to a known victim, there shall be no money bond on a 1, 2, 3 misdemeanor.
Absolutely.
Tara, you okay with that?
Absolutely.
Okay, the ability to pay, that a judge must assess a person's ability to pay if they are imposing a secured bond, and it must be in writing. And there is a presumption if one of those several conditions, that they've received a court-appointed attorney, they're a full-time student, they're on public assistance, they do not have an ability to pay any secured bond.
Completely agree with that one.
Yeah, me too.
The full-blown bond hearing soon after the first appearance, if they are held on a cash bond, there shall be a full-blown bond hearing, which doesn't sound very legal, but a robust bond hearing.
Yeah, absolutely.
Sounds good.
Sounds good. We've talked about the data collection, and I think we're all much more, wanting mandated data collection to know who's in our jail, why they're in our jail, what the racial breakdown is, that would be mandatory monthly reporting.
Support it.
And I don't know if that would go other than to DHHS, that's part of the information that would go to the Administrative Office of the Courts. Professor Smith, do you see a issue there?
I think it depends on what you're wanting to do. If you're wanting some oversight by the North Carolina Administrative Office of the Courts, the data would go there. The DHHS data is available. You just have to make an information request, as we have done. If you're, looking for the most open and transparent system, so community members and advocacy groups and everybody can look, you might have a public access website where it's posted. So I think it depends on what your objectives are, on who you want to provide that to, and who you, yeah.
Should we leave that open to flesh out?
Sure.
Getting to pretrial services, and I know the presenters gave us a lot of information on a jail coordinator, pretrial service coordinator.
I think I guess the recommendation could be if we appropriate pretrial services and supervision funding at county and state level to follow models of, again, I don't want to get Mecklenburg County a lot of hate because I know a lot of folks, but to model places like Mecklenburg County, Orange, and Durham. I mean, if it works well, the rest of the state can do it. It's good for you.
Okay. We're good on that, recommending the pretrial service approach, the models that have been presented. We've talked about,
Maury?
Yes.
I'm sorry, I just wanted to flag the part of the discussion about support for pretrial services where people might, where counties may be more rural and may not be able to afford it, and take the temperature of the working group about whether that's something that you all are interested in thinking about the implementation of, other than at the county level.
Well, and Noah's suggestion was that could there be some regional groups that come up, and so it's not just county to county. But I think at the very beginning of this discussion, we're talking about people's liberties being taken away. And, at the front end, the dire consequences that has on someone's life. So if we take their liberty, what investments are we making to make sure that was a just or unjust decision? Pretrial services, and I know there's a lot of discussion. Does law enforcement do some of the pretrial services? Does the public defender or a contract IDS attorney do it? Is it through the judge's office? There are a variety of ways.
I think if we include in the recommendation to model the counties that spoke to us, I think that'd be the best way to do it. And again, I know it'd be a strain on the counties, but again, we just talked about how much money it costs to keep people in detention as well. And then not to mention the continued burden that it would be once they lose their jobs and housing on these counties, and an additional threat to public safety. So the counties end up saving money in the long run if we do it right. But then again, I would hope that the legislature would step up and make some of these, would join in these recommendations to be a partner and supporter of these efforts.
Okay. I think those are kind of like the main flashpoints that we talked about. At least we can get the concepts of this is what we're agreeing on for changes for bail, taking away a lot of the cash bond availability, and encouraging pretrial service concept to be spread throughout the state.
Representative, I would, again, I don't remember I don't know if you wrote it down or not, but as far as the detention hearings,
yes,
especially for the much more, I think if we were to increase, it would basically be a mandated bond hearing instead of waiting on a defense attorney state to agree to when they can have a bond hearing. I think it's important to have those continued bond hearings within a certain amount of time for anybody that is having to deal with a secured bond.
Okay.
So I just don't know. I mean, Professor Smith, what do you recommend? Because like I said, in juvenile court, we do those every 10 days after that first review hearing. It could be a bit much for some places. What do you think is a decent amount?
Again, I sent the link to Jasmine and Alan that has all the models that are available to you, including the ABA recommendations. Again, I would just, note there are some places that don't even have court every week. So you're right. But if it's, if we're talking about a deprivation of liberty and a constitutional right, then they have to, court has to convene in some way to offer appropriate proceedings. So there'll be a few models in there. And as folks work on the recommendations, I'm happy to highlight those portions with you.
Representative Moore, we could come back to that and continue to
but
take a look at those models. Yes. Review. I mean, we could figure out the time, but review recommended detention bond hearings for those individuals that are sitting on secured bonds.
I'm with you. I agree. Okay, I think that's going to kind of cover the main issues that we can tackle today. We'll have to probably come back to it. And our next meeting is scheduled for September 30th. I don't know if people are available next Wednesday or if that's just too much, and we'll just come back to this after we hear from Juvenile Justice on the 30th.
And just another option is, I mean, if people want to kind of do some of this work over email, you know, we can do that too. We could send out a survey with some different options, and then each work group member could respond with, you know, if they like that suggestion, what else they think should be added or what they're not comfortable with. Maybe that would be easier, kind of seeing things in writing.
Sure, that would be great. And especially since two of our members aren't able to be with us today, to just get, I know we're doing basic concepts, but to do that and see where we are, and we'll check in later about adding another meeting. Let me hand it over to Natalia to just go over what we have done and the recommendations we have made.
Sounds good. Let's see. Okay, so I know we're running out of time, but I did want to have another opportunity for us to revisit the recommendations that you all have already made. So we have a recommendation on first appearance, requiring first appearance before a district court judge within 48 hours or next session of court. And also that all persons who remain in custody after the initial appearance shall be represented by counsel at state's expense. So one thing we could do here is, I know the senator mentioned incorporating the rest of the Alamance County consent order. So we can add things like the notice requirements and the other things that are missing. But I did want to take a moment if anybody has additional points they would like to make on these first appearance recommendations.
I think it looks good.
Okay. This one I actually think is in good shape and is pretty straightforward and clear cut, but we have our second recommendation being the local ordinance sunset provision. Anybody have any final comments on this one before we send it to the full task force? Okay. Next is our citations in lieu of arrest. This one right now is a little bit vague, which is okay. We don't have to, specify everything in the report, but I did want to open up the opportunity if we want to be a little bit more specific about, when we would require a citation in lieu of arrest. And then second, like Professor Smith has mentioned, we don't have anything in terms of summons in lieu of arrest if you want to also make a recommendation on that issue.
I do think the summons in lieu of arrest is equally as important to add in here, that it may not be a citation, but a summons in lieu of arrest. And maybe we could put in that any city ordinance or class 3 must have either a summons or a citation. It kind of fits in with our no cash bail. Don't bring them in the jail in the first place.
Okay, are other people comfortable with the class 3 and city ordinances?
Great.
Cool. And last, diversion practices. So this is another one where right now we have it as an encouragement, and I just wanted to flag that if we wanted to add anything more specific or best practices or other considerations for diversion programs. And I know Representative Mori in her email mentioned a few other characteristics.
There are some good models out there. The misdemeanor diversion program, if they had no prior record and they can keep the record clean, that several counties are now doing that. Some of the partnerships with criminal justice groups, it looks a little vague, but maybe we can help flesh it out with any more discussion by the task force, and especially the law enforcement working group 1 and 2.
Mm-hmm. Yeah, and I know other working groups are looking at the pre-arrest diversion programs from the policing side. So they may come up with some additional recommendations. Senator, any thoughts?
I'm just looking at some sort of language that would basically, kind of like we just talked about with issuing a secure bond, to make it a best practice or a starting point. Not just encourage. I feel like, because again, we can avoid a lot of these problems if we just, like Professor Smith also mentioned diversion in her recommendations, I believe. But if it could be like I don't know, maybe if we could tweak that language to maybe make it best practice, or diversion should be the best starting point. And obviously not everybody's gonna be diverted, but I feel like maybe we could use some stronger language as far as encouraging law enforcement and prosecutors to start with diversion before they immediately.
Yeah, especially if there's no criminal record.
Absolutely.
Great, I will work on that.
Could I add one other, was that all you had, Natalia?
Mm-hmm. Yeah.
I think we briefly talked about it, but for civilians that come down to the magistrate to try and get a warrant taken out, if it's a civilian, not law enforcement, that also should be only by summons to come to court.
Yep, I will add that to our citations and summons recommendation.
Senator Tara, are you okay with that one?
Yes. Natalia, if we could just go back to diversions, one thing I think that we should also consider in there, because again, I feel like diversion could be the best starting point, because then we avoid criminal records, we avoid folks that have been accused of a crime, but they still can't get this job or house because they have these pending charges. But even whenever possible, that we don't exclude necessarily folks with criminal history or mental health or substance abuse. Like, just because I have a criminal record, it might have been, I mean, you have to take account for how long it's been or circumstances. I think if we include language that says whenever possible, don't exclude just because someone has criminal history, I think that might be something that I would include in. I don't know, Representative Mori, Tara, I don't know if you all want to. Include anything else to it?
I mean, I would agree that they shouldn't automatically be excluded from the record. I don't know how you'd wordsmith that, but I agree that shouldn't be automatic.
Yep.
Sounds good. I can add and through this survey, give y'all one more chance to review it and see if you like it.
Thank you, Natalia.
Mm-hmm.
Okay, we're 5:32, and I know we're getting that time. Anybody have any questions, anything we have missed? We will get emails and do some work offline.
Real quick, Natalia, one last thing with diversions. If you could maybe include a point in it that talks about how prosecutors and law enforcement should always keep in mind the collateral consequences associated with charging someone. Like something that they always keep top of mind. Thank you.
Mm-hmm. All right, so just stay tuned for your emails, and please do read them and respond so that we can get to some good recommendations that have incorporated everybody's perspectives.
Okay. Anything from our task force chairs like to say?
Anita, if I can just I wanted to give you all a heads up that work group 2 is coming up with is making some recommendations about SROs. And so just to, because I know that overlaps with the juvenile justice system issues that you want to look at. And so I think you will learn about those in an email that's like a straw poll. And so just to kind of give you a heads up that that's on the way.
Great. Thank you. And there are other issues we brought up that we will be getting to, the marijuana and, you know, the legalization, decriminalization, that'll be coming up a little later. I know with charging issues that we had a little discussion about the habitual classification on certain that we will try and come back to. But we've tackled the big issues, I think juvenile justice, and then we will come back and start finding, you know, what we missed or what we want to still talk about and refining. Sound good? What a great group. Yeah. Who made me dinner? Come on. Thank you all, everybody. Sure appreciate it. So 4 o'clock on September 30th. Watch your emails for other polls, voting announcements, whatever. Thank you.
And I just want to say, Jasmine, Natalia, Professor Smith, thank you so much for being continued resource and so helpful for us. Can't do this work without y'all. So thank you, thank you.
That's so right. Thank you all. I'm driving on crazy, so. Combat pay. Take care, everyone.
Bye. Appreciate y'all.